Child custody can be the most contentious part of a divorce. As of tomorrow, Arizona parents and judges will face a lot of changes in how custody is decided, including removing the word custody. KGUN 9 on your side's Craig Smith asked a veteran family law attorney about the changes, and now Craig is live in our newsroom.
Well, Guy, the law recognizes that kids generally grow up better with two responsible parents active in their lives, but also recognizes divorce can deprive children of that. It does not even talk about custody anymore. Instead, that's referred to as parenting time, and that time carries a high priority. The law is designed to improve the amount of time a child has with both parents, but family law attorney Ann Haralambi says that does not mean divorced parents can count on a 50-50 split on time with their children. It directs judges to act in a child's best interest and be practical about it.
So if you have one parent who lives in Marana, another parent who lives in Vail, and you have a first grader who goes to school, it is not going to be practical to divide that child's time 50-50 in most instances.
Judges will also have discretion on whether parents can share control over important decisions of issues like education or health, or whether that decision-making power should stay with one parent.
Does this give a judge so much latitude that it could be a major change or almost no change at all based on how the judge interprets?
Judges have always had so much latitude to do pretty much anything they wanted that judge felt to be in the best interest of the child.
Haralambi says successful joint decision-making, and whether a judge will allow it in the first place, will depend on whether parents can put aside the anger they may feel for each other and pull together for the good of the child.
So I always ask my clients, do you love your children more than you hate or dislike your ex?
Now, coming up at 6, we will hear from a child psychologist with more on the psychological value of these changes.
Does this affect child custody arrangements in effect now?
Only if parents request it based on a major change in the child's situation. Maybe a parent has moved or the child changed schools and so on. It's not clear whether the passage of this new law is reason enough to change existing arrangements. It's possible state lawmakers may be asked to clarify that. So overall, this would just apply to new divorces after tomorrow.
All right, Craig, thank you.